271 on the drones, and I don't know if we have an actual amendment on that or conceptual amendment on that. Oh, we're waiting on Kyle. Okay. I'll wait until Kyle gets here, so if he's got the paperwork. There he comes, I see him. I'll give him a chance to come in and catch his breath here. Okay, 271, there we go. Kyle, I will let you explain 271 after you catch your breath there, sir.
All right, thank you so much, Mr. Chairman. So this amendment, I used the introduced version of the drone bill as a template because the idea of this amendment is to remove all of the language that restricts the use of certain drones and the transfer and reimbursement process that had been in the previous version of the bill. So it goes back mostly to the introduced version. However, it would retain the remaining amendments that have been made throughout the legislative process. And those retained amendments are reproduced here in this amendment. So under the amendment, a governmental agency would be prohibited from purchasing or acquiring a drone with critical components produced in any country of concern or produced or owned in any by any foreign principal. And this restriction would go into effect upon the bill's publication in the statute book. That's July 1st, 2024. A governmental agency could still use any replacement component acquired prior to July 1, 2027. But no new replacement component could be acquired from any foreign principal unless such component cannot be procured from another source. You'll see on the third page, the conference committee had agreed to move section 6 of Senate Bill 37 into 271, and that is shown there on page 3. Thank you, Mr. Chairman.
Thank you, Kyle. Committee, any questions? Senator Fauscadeau.
Thank you, Mr. Chairman. So those drones, with this amendment, is saying that you won't be able to purchase them. But if an entity has already purchased some, can they still use them, or how does that work?
That is correct, Mr. Chairman, and Senator Fauscadeau. The governmental agency would not be restricted from using that drone. But once the drone is no longer in working condition, they would be restricted from acquiring a new drone from a country of concern.
This just allows attrition to take its toll, and eventually you're going to get rid of them all if we restrict any further purchases. Yes, this will take, upon publishing the statute book, which would be July 1st, 2024. So after July 1st, no governmental agency could make a purchase of a foreign entity.
Just curious, how would that work? Like if there's some agencies that already have like something in the workings, maybe they have a contract. I mean, I don't know, because there's a lot of them out there. A lot of them being used. What if they're already under contract for so many of them or something? How would that
See what that work, Kyle?
I'll defer to Representative Tarwater if he wishes, but I would imagine it would be set by the actual official date of acquisition, not whether it's in process or not. So if it is under a contract that's ongoing, but they end up not actually acquiring ownership of the drones before July 1, I'll defer to Representative Tarwater.
they've got them on order already? Maybe they had to put something down on it already. I don't know. I'm just curious.
I don't know I don't know that that particular instance is referenced in here. It just says they can't purchase new ones. I don't know if the purchase date would be defined as when they contracted for them or when they actually take ownership of them.
Because you would think with the amount of money being spent on these, there would be, in most agencies, they're already planning, they're putting things in play beforehand. And so I just don't know. We don't know enough about this situation, but that was a thought that came to mind.
Is this a Senate amendment? This is your amendment?
This was our suggestion, but obviously, we're taking a big bill, shrinking it, but now that we see this, and I think this is a good amendment, but that is kind of an interesting take that we hadn't had time to think about. And so I'm guessing if a contract had been signed, but they hadn't delivered the drone, it would be essentially a sale. But any contract, I guess the gray area would be the contracts that were pending that span that time period, straddling the July 1st enactment date. And I don't know if there's a conceptual amendment that we could make that would consider that type of variance. If you have a suggestion, Kyle or Jason.
A couple of things to think about. First, I think perhaps you could use similar language that's used there on page 3, that portion of Senate Bill 36 that had been agreed to be added. The very end of it says the provisions of this section shall not apply to any contract or agreement entered into prior to July 1, 2024. So that's something that could be reproduced for this drone portion of the bill as well.
May enter into. That seems reasonable. Yeah.
If the revisers can draft that, we're good with that.
Very good. Yes, we could.
Representative Probst has a question.
Thank you, Mr. Chair. I know in one of our previous versions, keeping track, there's been several, we had changed the language around country of concern. It looks like in this version, we're back to the original listing. One of the versions, I think the amendment that we had put on, it's a different bill.
That's the foreign lands.
So for the purposes of this bill, we're okay with defining specifically instead of using the general language around the Department of Defense or CFIUS as far as country of concern. Because I think the idea in the other bill was that that's a changing living list that may change from time to time. And I guess I just want to make sure we're okay having a static list instead of one that's dynamic.
I think that would be a policy issue. I mean, the other one, in the other one, you're right. There were 14th Amendment concerns on the other one, and I don't know that they felt like there was that same concern here. However, we could also conceptually refer to that list, which would essentially be the same right now. And if there were an adjustment on the federal level, it would include that. I don't, if you have thoughts on that.
So both lists are static. The one lists the countries, the other one lists the federal list as of a certain date. And if it changes going forward, it does not change either one of the bills.
Okay.
So they're in a sense the same.
Exactly. Any further thoughts? Senator Faustido.
Thank you, Mr. Chairman. either of the staff revisers, if you could tell me the major difference between 271 and then the original or this bill introduced by Representative Croft, the 2820. So is this the amendment we're wanting to put in 271?
That is correct. And as previously stated, I used as a template to show the balloon the introduced version of this drone bill. And the major difference is that it removes the use restriction on governmental agencies who have restricted drones, and it no longer includes the transfer, prohibition of sale, and reimbursement portions of 271.
Which got to be very convoluted, to be honest. Yeah, yeah. So, Senator Cluse, you good, or? You don't have anything else? You good with that? Okay. All righty. You okay with this? Okay, I think we can agree on this.
All right, so can you restate to what we're agreeing to?
Mr. Chairman, this amendment would remove all of the language of the underlying bill restricting the use of certain drones in the transfer and reimbursement process that was in the previous version of the bill. It would retain the remaining amendments that have been made throughout the legislative process. You'll see some of those different amendments off to the side. Like on page 2, the stricken language for drone, that's something that was in 271, the version that was in conference. I was just showing it here for visual purposes. And then under the amendment, governmental agency, again, they would be prohibited from purchasing or acquiring a drone with critical components that were produced in a country of concern. And that prohibition would start on the effective date of the bill, July 1, 2024. The agency could still use their replacement parts that they acquired previously to 2027. And then lastly, this amendment, similar to the previous version you saw here in conference, would have Section 6 added from Senate Bill 37 that states that no state-level agency shall enter into a contract or agreement to procure final or finished goods or services from a foreign principal. Thank you, Mr. Chairman.
And you would also conform for the contracts piece in the front with the drone?
Yes, and that conceptual change to add that language to
Okay.
the drone piece.
One last question?
Yeah, yeah. So when you say they can purchase, who's they?
Governmental agencies, any governmental agency, yeah.
Right. For the drone portion of the bill, it's for state level all the way down to local level. But for the section that was taken from Senate Bill 37, that is only state level.
I believe we're in agreement. I don't believe there's any other amendments to discuss, so I think we're good to go on this one. So,
Go.
what do we need to do, Kyle? Anything, make the signature now or finish up first?
I will need to finish preparing the formal document to sign, and we can track you guys down later to get the signatures.
It may end up being in veto session depending on what time we got to get this done first. So, okay, I think we're good with that. Now let's move on to House Sub for Senate Bill 172. And I know we've had a lot of talks over the last day or so about amendments. Refresh my memory, Kyle, what we left off. I think we made some amendments, had an agree to disagree. So, but I believe there are some further amendments coming our way. So let's talk first about the Attorney General's amendments that we had discussed, or did you come to some agreement with your side with regard to the takings amendment.
All right, so I think we have an amendment that encompasses most of what the Attorney General was trying to accomplish. It also has some clarifying language from Senator Fascato's question yesterday regarding timeline. When she asked that question, she inadvertently, she caught something that was incorrect in the bill, and we want to make a correction there to give people a better opportunity to fight this and have more time. Also, the takings part, they're still working on the exact language, but we can discuss what that sounds like as a conceptual amendment.
We have,
Start with what we have in writing so far.
yeah, I think we had an original amendment that had 3 different balloons, and one had the takings on it. The language that we had. If we want to start with that, maybe? What's that? Oh, yeah, let's go ahead and take a look and see what you've got. Do we have, is that the, oh, there they are. Thank you. I'll let you go ahead, or,
Yes, thank you, Mr. Chairman. And this also shows the amendments that were agreed to by the conference committee yesterday. So starting at the bottom of page 1, changing that definition of country of concern to cite to that federal regulation instead of listing them out individually. And then page 4, reducing the mile restriction from 150 miles to 100 miles. And then further down in section 3, this is, the general restriction language. And so I'll read it how it would read now with the removed language, that in C1, any foreign principal that directly or indirectly owns or acquires any interest in real property is described in subsection A, shall divest such interest in such real property. And this is the first part of the amendment that's it's sort of adjusting the overall timeline in this process. So this first broad restriction that's in section 3 just states that if you meet these conditions, you register within the 90 days, but you are required to divest. But then moving down to new section 4, another change that had been agreed to yesterday is removing the portion that states that a third party may report to the Attorney General. This change does not in any way preclude someone from making a report to the Attorney General of a violation, but there was some concern that maybe the Attorney General would need to receive a report in order to start an investigation. So that language is stricken, and it would just say now the Attorney General shall investigate any suspected violation of Section 3 and amendments thereto. And then language that's just been added here today for this amendment then is there in subsection B at the bottom of page 5 that says a foreign principal who is subject to the requirements of section 3 and amendments thereto, meaning that they are a foreign principal with real property within the mile radius, may enter into an agreement with the Attorney General to divest such foreign principal's interest in real property not more than 360 days from entering into such agreement. And then moving to the next page, there's the existing language that states that the Attorney General can commence an action in court. Some of the immediately preceding language is stricken. It used to say upon finding a violation of Section 3, then the Attorney General could seek action in court. But now it would just state, generally speaking, that the AG may commence an action in a court of competent jurisdiction to enforce the provisions of Section 3. The existing language had the relief options for different court orders. to enforce the act. But then moving down, there's a new subsection D1 and 2, and it would state, upon a determination by a court of competent jurisdiction that the defendant has violated the requirements of Section 3 and amendments thereto, the defendant shall have not more than 180 days from the date of such determination to divest such defendant's interest in such real property, or to otherwise come into compliance with the provisions of Section 3 and amendments thereto. So to pause right there for a moment, that creates two different avenues where a person can go to the AG and enter into an agreement with the AG to divest if they're required to by this act. And if they do so, they have 360 days to complete that divestiture. But if they are taken to court and they are have a court order to divest, their timetable would be reduced to 180 days from the date of that court determination. And then further down in D2, this language is what's still being worked on right now, would state that if such defendant is ordered by the court to divest such defendant's interest in the real property, and such defendant had acquired such interest prior to July 1, 2024, so they had acquired that interest while it was still allowed, such defendant may file a claim against the state pursuant to state law for any reduction in sales price of the real property caused by such court-ordered divestiture. And then further down in new section 8, still the same changes concerning the report that the AG would send to different state officials. And then a new section 8, which was agreed upon yesterday, requiring the Kansas State University to submit a report concerning all foreign land holdings of real property in the state of Kansas. And that is it for the changes. Thank you, Mr. Chairman.
Okay.
Senator, do you want him to repeat the part about the takings?
No, let me
He did
just,
put that in
if
there.
I could just read it over for a minute, and I think I can kind of digest it and let my committee also read it over here and make sure it's doing what I think it's doing. So let me ask you this, Kyle. This just immediately throws it to a claim against the state. Is that correct? Or is there, I can't see if there's any like negotiation, the amount of compensation between the fair market, or maybe I'm missing it, between like the fair market value and what they're being forced to sell it at. Is there any, maybe I'm missing it.
Page 6, there on line 20. That's some language that I can still work over with Jason. Right now, we were discussing if maybe the word for any reduction in sales price, maybe for any difference in sales price would be better wording. The idea being that if an individual is suddenly ordered by a court to divest their property, they might get a lower amount than they would if they were just given fair market value.
Okay.
To clarify, that is authorization to file a claim in court, not to go directly to the committee that we have here, claims against the state.
Right.
I didn't want to confuse the two issues.
Yeah.
This gives them authorization to try to recover the difference in sales price under the Takings Act.
Okay.
Mr. Chairman, I would disagree with that interpretation. This directly cites to the claims against the state statute process. So from my understanding, they would, in fact, be able to go to the committee, claims against the state, to try and be reimbursed.
That's the way I read it. So it doesn't really allow for some kind of negotiation of compensation for takings that I see. I think they just file a claim against the state, and we would have to come up with the money. Yeah. 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 Let me, before we can agree to this, I would sure like to have a chance to digest it, and I hate to keep putting it off, but I want to make sure I'm not agreeing to something that is not where it needs to be. So I like a chance to maybe recess for a while. See, what time is it, 6:17? I don't know what, I'm not sure what's going on the floors. Does anybody in here know, Elena? Or, this is, I have no clue what.
We're back on the floor at 7.
You're back on the floor. We're still in recess now. And you're back on the floor at what time? 7:40. I have no idea what's happening for us. And I'm sure you guys would like to get your dinner break in. Why don't we, this is
much more important than
right.
dinner.
Why don't we, 6:18, why don't we give us about 30 minutes or so to sit and digest this and make sure that that it's fully thought out before we can agree to make sure we get the language right. I want to make sure.
Okay, Senator, so we can agree to that, but let's hash out everything else so that when we come back, we don't have to leave again. Let's get it down to just the one clause that we're worried about, because we both want to get there.
Right.
We both want to get that clause right. Can we have an agreement based, everything else? I mean, we had an agreement yesterday, then we wanted more changes, so.
Right.
Let's get it down to just one thing that we can negotiate from this day, this minute forward, so we can get this done.
Yeah, if we can get that language right, that'll be very helpful. The other concern, there is one other concern that came up that with regard to the CFIUS reporting requirement and the time. The concern was that there may be some issues with companies that are being thrown into this situation that immediately may or may not qualify for a CFIUS reporting because they are not considered a foreign adversary, but yet may fall under the influence of this bill, under the requirements of the bill. And it would be good, I think, and probably prudent to extend the CFIUS filing requirements to, let's say, March 31st of 2025, so that if we were to have some conflict that we did not consider with regard to some businesses that got captured into this bill that through no fault of their own, were all of a sudden caught up in making those CFIUS filings, we would have a chance to fix it during session next year. And give them a little bit of time to file. From what I understand, the CFIUS filing can take several months, and there's some legal fees associated with that.
Kyle, would you give us the rundown again, once again, on the CFIUS timeline for requests?
Mr. Chairman, I have a document on file that does give the timeline for CFIUS review, but I have a more preliminary question. If Senator Thompson is in effect asking for a delayed effective date for the entire bill, I would have to figure out how to draft it. Where is it, or someone with a pending investigation with CFIUS, they would have until the March date?
Yeah, this would be on the actual 172 on page 5. Any action concerning covered transaction pursuant to 50 U.S.C. 4565 as in effect on July 21, 24. I believe that refers, I think, to the CFIUS filing date.
Well, so I should reiterate, and it is a little bit confusing to read, but when it says pursuant to 50 USC 4565 as in effect on July 1, 2024, that July 1, 2024 date is that's modifying the statute itself. It's saying that pursuant to this version of the federal regulation, the version of the regulation that was in effect on that date. So entities after that date could still seek CFIUS review ongoing. So when this date goes into effect, certain companies that have already received CFIUS review and are not recognized as a security threat would be exempted from the bill, but also entities that seek CFIUS review within the 360-day timeline could get that review and become exempt. So this isn't just...
So they would essentially have a year to file? Well, I guess they wouldn't, because they'd have to have, the clock starts ticking on July 1st for the CFIUS filing if they had not filed, but all of a sudden fell in a situation where they needed to file to be able to get an exemption.
Under the change made in this amendment, the clock for registration would start on July 1st. They would be required to register, but they could voluntarily approach the AG to enter into a voluntary agreement concerning divestiture. And I would imagine they would let the AG know that they are seeking CFIUS review and keep him apprised of that situation.
Okay. Let's also put that as part, make sure that we're doing the right thing, I think, as part of this conceptual amendment with regard to the takings and then the reporting, because I think we do need to give them a little bit of leeway on some of these things that maybe we're not considering. Maybe we can talk about that during our little recess break to make sure rather than try to hash this out here where we may or may not be understanding fully what's going on. So those are two things. One concern I know was the reporting, expanding the reporting requirements beyond K-State. And that was actually in a balloon that was, did we offer that balloon, Jason? We had not offered that balloon, but if I could take a look at that.
That was offered in discussion with the AG.
Yes.
And it was determined that we would not accept that.
You would not accept that.
And he was all right as long as we accepted the terms of having the takings.
The takings, okay. Well, let's tackle the takings. Let's tackle the CFIUS timeline. Give us a little bit of time to make sure we get this language correct. How much time would you need, Kyle? Or did you have a? Yeah, I think we can, let's deal with the taking. Did you have a question?
Just outline it.
Let's, okay, I think we've got, let's work on the takings. Let's check on the CFIUS timeline situation and meet back here at 7 o'clock. Sound reasonable? Okay, thank you. All right, I just want to make sure. Okay, we've got, I think we've got Kyle drew up the amendment with regard to that, the takings clause, and I think we're good on that. I don't know if you have the language yet, or I'm guessing this is going to have to be drafted up between now and the veto session, I'm guessing. I don't know what time we're planning on getting out of here, or if we're getting out of here.
We need to run this today.
Oh, finish up today. No, I'm talking about getting the language.
Bill needs to be passed today. Because when we come back, we're going to adjourn and we're not going to have the ability to come back if it is vetoed. This is a national
see what
security
you're-
bill.
I see
We've
what
gotta
you're
get it
saying.
passed, and it's got to stay.
I see what you're saying. Okay. Depending on what time the conference committee report can be produced, of course. So, Kyle, can you talk to me about the progress on language? I think we're good on the language, the takings language.
Just to take a quick step back, I want to direct your attention to the completed conference committee report for the drone bill 271.
Okay.
And I have copies here. If you'd like to discuss that first, it might be quicker to resolve.
Okay.
And so the last remaining item for that bill, oh, that's right, I need to distribute them to the, to the members, was the exemption language for contracts and agreements entered into prior to July 1, 2024. In one moment. And that language can be found now in the drone section of the bill at the top of page 2, subsection D. It states the provision of this section shall not apply to any contract or agreement entered into prior to July 1, 2024.
So Kyle, this would pertain to the purchasing of drones, right? Not parts, because we don't want to have ongoing contracts for parts. Would be for contracts for purchasing of drones.
This would be in regards to drones, including, I believe, the maintenance agreements and related equipment. That language is already part of the underlying bill, and the restriction language that states the governmental agency shall not purchase or acquire any drone or any related services, maintenance agreements, or equipment, the critical components of or derived from a country of concern. And so the new language would exempt contracts and agreements entered into prior to July 1.
Senator, was it your intent to cover future parts? So let's say that between now and then, this company decides it's going to offer contracts
No.
parts forever.
No.
So your intent was to cover drones that are already purchased, that are being shipped and haven't arrived.
Simply those, yes, exactly. In other words, a purchase was made, maybe it hasn't been delivered yet. A contract for a purchase was entered into prior to that date, but not delivered yet. So just to cover those that are in process. But beyond that July 1 date, everything's off. So that,
Not a long-term maintenance agreement.
no. That,
We need to make one more. I think we need to change that a little bit. Okay.
yeah, I agree.
Sorry, Kyle.
More work for Kyle. More work for Kyle.
Just a clarifying question, Mr. Chairman. Your intent is only to address contracts or agreements for the purchase of drones. That's your intent? Okay. If the purchase contract, okay. if the purchase contract includes maintenance or replacement of component parts as part of that purchasing agreement, and that agreement is entered into July 1 of 2024, would that be covered under this provision or not?
For the same 3-year period that we have, but after that, no.
Okay.
If it's prior to, I think it's just really, we're talking about that lead-up time, you know, between the time, basically it's between the time that the bill is enacted and that July 1st. Now, we could perhaps circumvent that by changing the enactment date to publish in the register, which is like 15 days. But I guess you still have that problem, though. You still do have that problem, because anything that's entered into and agreed to by that, or before that time. Right. We don't know how many. I don't know how that language might look. Jason, do you have an answer or thought?
I guess my thought is if they've contracted to purchase the drone, say on April 1st, and that includes maintenance provisions and replacement of part provisions with respect to those drones, and then those drones are delivered, say, August 1st, after the July deadline, this provision would allow them to go ahead and keep and use those drones, even though they, you know, came into their possession after July 1st because they were purchased prior to July 1, and the maintenance provisions of that contract would apply to those drones. Is that your intent, and to allow that that type of contract to move forward and be valid after July 1st?
I think you run into trouble trying to, again, retroactively invalidate a contract. If something is enacted on July 1st, then you run into lawsuit issues with that. I think, as I understand it, you would have to allow that to continue. That just falls into that gray area, and who knows how many drones that would be involved. But I'm not sure I see a way around it. I mean, we are.
Just sign the damn contract. Let's just go ahead and move.
Yeah, okay, okay, very good. So this does, it takes care of that situation. Okay, all righty.
It does exempt any agreements that were entered into with respect to the drones, related service agreements and maintenance agreements that were executed prior to July 1st of 2024.
I think that's probably the wisest course of action. So just sign this. Okay. Oh, that was on the other one. Yeah, this is on the, yeah, because this, we're
Let's move on to the next one.
Very good. Very good. So we've got that takings clause that we discussed. So we're talking about that. So that takes out the list, which is what we need to do for the 14th Amendment. All righty, let me review this language just so make sure I've got it correct. Basically, bottom line, page 2, we changed the list to reference the foreign adversaries list, the national foreign adversaries list. Good with that. Change the radius on page 4 from 150 to 100 miles. New section 4, we strike everything except just the Attorney General shall investigate any suspected violations of section 3 and amendments thereto. And a foreign principal who's subject to the requirements of section 3 and amendments thereto may enter into an agreement with the Attorney General to divest the foreign principal's interest in real property not more than 360 days from entering into such agreement. So the clock ticks, they have 360 days to satisfy the section 3 requirements to file. Make sure I'm correct so far. On page 6, this is this would be the takings clause. Oh, yeah. Make sure, basically on this takings clause, I'm guessing subsection D, 4, D1 and 2, that's the takings clause, correct? Which would put it in, if they'd have certain time to divest, 180 days from determination to divest defendant's interest in real property or to otherwise come into compliance with provisions of section 3. If they're ordered by the court to divest the property, they may, and such defendant acquired such interest prior to July 1st of 2024, the defendant may file a claim against the state pursuant to Article 9, Chapter 46. So that is our takings clause. Then at the bottom of page 6, the Standing Committee on Fed and State, there will be a report on or before February 1 of each year, and it includes the Governor, Adjutant General, Commerce, and adds Standing Committee on Fed and State Affairs of the House, and on the Senate side, detailing the implementation of the Kansas Land Military Installation Protection Act, which is this. On page 7, Kansas State University used data and resources to prepare and submit a report to the Legislature and the Attorney General detailing the status and trends of all foreign land holdings. So that's our collection of data. And then renumbering of sections thereafter. So I think we're good with that. The only other thing that we ran into that is of a concern, and maybe I'll have Jason explain this, there are certain entities that cannot file for a CFIUS exemption. And therefore, when this goes into effect, it places those entities in an unenviable position of not having any legal recourse. And from a legal standpoint and a defensible standpoint, I believe we need to give those entities at least the opportunity to file for an exemption. Doesn't mean that they're going to qualify. Do I understand that correctly, Jason? Have I correctly restated that or stated that?
Mr. Chairman, yes, there are certain transactions that are not subject to review by CFIUS, and therefore they could not get a determination as described under the current legislation and the bill. For that, they would be just not covered by a CFIUS review.
And as I understand it, and correct me if I'm wrong, this would be, we're likely to, no, it's not likely, we will get lawsuits. The state will get sued over this bill because of the retroactivity. But this gives us a more defensible position in court for the state to defend, adding this provision for those entities that are unable to file. Am I correct in that statement?
Mr. Chairman, I'm not in position to opine on the defensibility of the constitutionality or other legal implications of this act at this time.
In my conversation with others who are in that position, that's what they're telling me. So I'm trying to give the state the most defensible position possible so that when it goes to court, we have the most legally defensible position we can, that we gave entities like this an opportunity to file or file for some kind of an exemption. And so we're working on some amended language, and I don't know if Kyle or Jason, how do you want to deal with that language?
Mr. Chairman, we could describe conceptually what that language would look like, and the committee can discuss whether or not they want to include it in the committee report. As I understand what you've described, you would want language that the property essentially receives notice within 90 business days that the CFIUS has declined to review the transaction or is not able to conclude action under the federal statute with respect to the transaction because that company, that transaction is not, is an accepted transaction from CFIUS review.
Would that give them then blanket exemption? Or could the Attorney General under this bill still investigate them?
Mr. Chairman, it would fall under the portion of the bill in which the entity can continue to hold the land if they have registered the real property as required. And then there are two additional conditions. One is that they've received a determination that they do not pose an unresolved national security concern after a CFIUS review, or that they've entered into a national security agreement with the Committee on Foreign Investment in the United States. This would be a third condition, optional condition for the entity, that it has received a determination from CFIUS that the transaction cannot be reviewed or they cannot conclude the action because it is an accepted transaction.
So but it wouldn't exempt them from investigation by the Attorney General if he felt like, even though they didn't qualify for registering for CFIUS under the CFIUS guidelines, it wouldn't give them a blanket exemption. The AG could still, if they determine that entity might be something that need review, this bill still would give the AG the ability to investigate and take action if necessary.
If you wanted to add additional language to direct and authorize the Attorney General to do so, you can do so. And so there would be so you would have the language under the bill that does carve out a blanket exemption for those entities that have gone through a CFIUS review and received their determination or have a national security agreement. You could have a separate exemption for these entities that have an accepted transaction, and then still authorize the Attorney General, though, to investigate whether or not, but I'm not sure exactly what the Attorney General would be investigating, because the Attorney General is investigating violations of the law, which means you're holding the land in violation of the prohibition, the general prohibition. What we're talking about here is exemptions from that general prohibition. So either you've granted them an exemption or you haven't granted them an exemption. If you want to grant a discretionary exemption, you can authorize the Attorney General to review these transactions and grant a discretionary exemption. If that's what you're recommending, we can craft language to that effect.
And this is a very complex situation because, again, somebody's going to claim you didn't give us an out. You didn't give us an opportunity. You know, if we can't file with CFIUS, if CFIUS can't determine that we're safe, we fall through the cracks. What do we do? How do we either prove that we're a safe, non-threatening entity? I think we have to have some kind of review of those entities. Thoughts on this, Chairman Tarwater?
I'm just curious as what your bill said. How did your bill address this?
Our bill was not retroactive, and so the bill that we had created a land council who reviewed all foreign transactions, and then that land council would approve those transactions on a case-by-case basis. They would investigate and determine that the entities were safe, or if they determined that they posed a threat, then they would reject the land purchase. But that was prospective in advance of that purchase, so that we don't get into these situations where we're going to get into lawsuits. That was the approach that we took on the Senate side. It was not retroactive, so the folks who are here, and it avoids these legal issues. But since retroactivity is the main effect of this bill, you know, going after entities that are already here, then you do fall into this situation where, I mean, obviously, these exemptions that we have in this section for, you know, the CFIUS to determine that they're a non-threatening, that's an exemption, or they enter into an agreement, that's an exemption. I think we have to have an exemption for those who don't fall under those categories, but we also need to give the AG the authority, or somehow the authority, so they don't have a blanket exemption. In other words, the CFIUS review and the agreement with the U.S., those have some review process in it. This exemption would not, unless we put it in there, and it would just be, we have to determine who we trust to make that review process critical. And maybe perhaps it's a KBI. Representative Prost, do you have any thoughts?
Thank you, Mr. Chair. I just want to make sure I understand what you're proposing here. Since we are working in a conceptual space, your proposal would be that we carve out a third condition that exempts somebody from this law, that says if they've applied for a CFIUS clearance and CFIUS says we're not going to review you, you don't meet the qualifications for our review, then that creates an exemption. That as the languages you've proposed would do that. But what I'm understanding is that you're uncomfortable with that, and you want to then create another process that says if this condition exists and CFIUS says they're not eligible for review, then you would want to create another mechanism that allows the Attorney General to have an investigation, and then that office is then tasked with creating what criteria then are they going to use, and what resources do they deploy to make that determination?
In my mind, you might, and it doesn't have to be the Attorney General. It could be another, perhaps it's the KBI, somebody who has the wherewithal to look at an entity and determine whether or not they're a threat. But since we have these other two carve-outs and there's a review process, these entities appear to me to fall into the cracks where it's ambiguous as how to deal with them. And the only way to deal with them is to make that extra exemption, but put a review process into place. And perhaps it is the KBI, because they would have the investigative wherewithal to be able to look at those entities and determine whether or not they became a threat. And if they are a threat, then they fall into the divestiture portion of the bill. Representative
My
Prost.
next question on that then, Mr. Chairman, would be, if we do that, whether it's the AG or the KBI, or we create a panel or whatever it is we want to do, for that review process, do we want to leave that open-ended, or do we want to define then what the determinants are on whether somebody that's not eligible for a federal review, we're going to handle this at the state level now, do we want to leave that open-ended, or do we want to define what the qualifications are for not being eligible or to be considered a foreign principal?
I would think that what we would want to do is have whoever it is, KBI, AG, determine whether or not they are a threat. And that part you may have to leave open-ended, because there may be various ways that they come up with to determine that. But you probably would want to set a timeline, which is what we were attempting to do in the Senate bill, so that you wouldn't leave it open-ended. As I recall, and I'm trying to remember the timeline we set, I think any time that a purchase of that type took place, the review process had to begin within 30 days, and then they had a total of 45 days upon the time that they took up that investigation to make a determination. We also gave them a little leeway in that if within that 45 days they felt like the investigation was not complete, they needed more time, they could ask for more time, but they would have to provide that entity with, how much time they expected that to take and the reasons why they were still investigating them, what they still needed to determine, so that they could not keep putting it off over time. We want to be able to resolve these processes quick and timely, but obviously the agencies don't have unlimited staff, and so we have to determine that. But I think that would give us a more defensible court position for the state, but yet cover those entities that are not covered under those other two exemptions, and maybe pretty much cover everybody. Sure. Does that make sense, Kyle and Jason? Go right ahead. Yeah, please.
All right, so there are other ways for this to be challenged, and these, you're worried about small companies, first of all, that may or may not qualify for the CFIUS.
Right.
Those entities that don't ordinarily qualify under the current Treasury rules can apply to the Treasury, and they can apply to the AG and the Fusion Center for status. And they can form agreements with, on number 2 there, the what page are the exceptions on?
I'm looking.
Page 5.
mind. I see it on page 5 of the original version. It's in section E1 and 2, A and B. So it says, any action concerning a covered transaction pursuant to CFIUS as in effect on July 1st, if CFIUS concluded they've got a determination from CFIUS that they are not a national concern and they have not undergone a change in control that would constitute a covered control transaction, then that exempts them. B, the foreign principal has a national security agreement in effect on July 1, 2024, and has determined by the U.S. or the U.S. Department of Defense and continues to maintain such national security agreement. That's an exemption. So CFIUS or an agreement with the U.S., but we don't have anything for those entities that fall through the cracks, that don't qualify for either, unless
Sorry,
I'm
Mr.
reading that incorrectly.
I did just want to remind the conference committee that in the definition of foreign entity, when it's talking about individuals, and this is on, the numbers are a little different on the Delta, but, it's the definition of foreign principal. It says any individual who is a citizen or resident of a country of concern and is not a citizen or lawful permanent resident of the United States. So for individuals from a country of concern who are a citizen of a country of concern and start a small business, say in the state of Kansas, another avenue is seeking citizenship or permanent lawful residence. So that is another pathway to receive an exemption.
All right, so there are other ways. My point is there are other ways to get exemptions. We did try to incorporate what other states were doing that are tried and tested. This bill goes far beyond for the protections that the AG wanted for training wheels on this thing to make sure that he can win. I get that he doesn't want to lose.
Right.
But if we wrote every bill up here to avoid a lawsuit, we're going to pass 100 bills, and then in this week, 25, 30 of them will be sued on this year. We can't not write laws because we're going to be sued. We can try to write them to be the best we can and to protect ourselves from lawsuits, but we will be sued. We're going to get sued under this immediately, I'm sure, just like every other state has.
Right.
And we think that we have given the AG enough to defend ourselves, and we're going to lose some lawsuits. We're going to lose some lawsuits, but this is a national security issue.
Well,
You know as well as I do, this is probably one of the most important bills that we're negotiating this year and probably in the last 5 years. So we've got to get something done, and we can't inadvertently come up with a loophole that would give a lot of people an out. If these people are bad actors and they are here to kill us, I don't care what day they arrived in the state of Kansas. And if we're going to have suffer through some lawsuits to protect this state and this nation, then so be it.
But, the defense is paramount, no doubt about that. Any thoughts, Vice Chair Cluse? Or, okay.
It's kind of what I was going for. Not really.
I understand.
And agreeing with what you're saying, but it's still our responsibility to make sure we're doing it right. And we're rushed in so many levels, just like with this drone thing that we just dealt with. We still have that on us. We want to do it. We're not disagreeing with you, but we want to do it the best we can and save our taxpayers. We know lawsuits are coming, but us and our way of thinking, that's one thing, but we have a lot of other constituents that don't think like that.
So if that language is unacceptable, I guess the bottom line is we would, let me make sure here that I'm not speaking for my other chair members. I think we can agree with that at this point. I mean, obviously, this is going to be a bill where we're going to find things out, and next year we may have to tweak it a little more. Just trying to make it the best bill we can right now, and that's what this discussion, in my mind, was all about. So, can we get all this drawn up then with the language? And I think we've come to an agreement then. Okay. Thank you. Thank you. Thank you very much. Thank you.